Good evening and welcome to Athens City Council. It's Monday, May 23rd, 2022 at 7 p.m. with all members of council present. We are in committee meetings tonight. We have 5 different committee meetings with a number of presentations by folks. What you'll notice is council members getting up and down from the dais as different committees are announced. That's because the particular committee who's having the discussion, like our Transportation Committee will be first, those members will be up on the dais. For any one of these topic discussions, we're expecting to keep within our limits, hopefully, of 15 minutes. The chair of each of these committees will operate that particular committee meeting in the manner in which they want to have things discussed, and will call upon people. Members of the audience are welcome to make comments when they're called upon. They give their name and address and whether or not they represent a group, and you have 3 minutes. And we will set the timer for everyone tonight. It's a little green, yellow, and red indicator up on the behind the lectern for you. So welcome. We're glad to see you here. It's always nice to have people in the audience making comments and lending to the discussion, and we look forward to that tonight. Our first committee is the Transportation Committee, and this is chaired by Councilmember Reisner and joined by Council Members Grace, Ziff, and Swank.
Thank you, Madam President. The Transportation Committee has 4 topics tonight: parking, towing regulations, municipal bridge projects, Ohio Public Works Commission issue of 1 funding application, and West Washington Sidewalk and Safety Improvements Project number 335. So the first topic is parking and towing regulations. This is an issue that has come up before council several times over the past, I don't know, since I've been on council, and that's been over 10 years. And for whatever reasons, never seems to get anywhere. Hopefully we can get the matter through this time. I have before me the proposed ordinance and an opinion about the laws that govern towing in the city and in the state. Those are on the Google Drive for anyone who wants to look at them. I don't want to have to read through all this, but I will turn to our law director and allow her to give us a summary of what her opinion is.
Well, back in 2009, President Nisley asked me to write an opinion regarding towing in the city of Athens, and I wrote several pages regarding towing and the tow charges. I think specifically what council, or specifically President Nisley, was interested in was the towing fees. So in this memo, I explained that there are 2 types of tows. One is under 451360, and that's a tow ordered by law enforcement from a private residential or private agricultural property. The second kind of tow is 4513-601, and that's from a private towaway zone. And those are like parking lots that a property owner establishes a private towaway zone. We see those all over town, and those are specifically regulated by 4513-601. There are very specific things that a property owner has to do. It has to be properly marked. There are certain things that have to be on the sign. And under that section, tows from a private towaway zone, if a tow truck company doesn't follow each and every one of those, then it also provides for a penalty of a minor misdemeanor. So those were the 2 kinds of tows that I looked at, and I had to look at a lot of different sections of the revised code, and specifically I looked at revised code 492125, and I wrote an opinion. It's my opinion. I know that there are differing views, and I remember Council Member McGee had a different interpretation. My bottom line with all this was that the tow companies are regulated by the Public Utilities Commission of Ohio, and that they would set the fee for a tow from a private tow-away zone. However, if it was a tow ordered by the police chief from private property or from agricultural property, that the city could set that fee. That was my opinion at that time. It was before council, and council did not act on amending the code. And the code states that it's for a tow. It's towing in private towaway zones, $50 for a tow. And the revised code and the administrative code says it's not to exceed $129. So this has been the same since 2019, and we don't regulate towing right now in the city of Athens. That's not my decision. It's been that way for about 25 years, and we have no provision in the code that would state what would happen if a tow company charged more than what we say here of the $50. So we have no way as a city of enforcing anything as far as what a tow truck company charges. And this is what I've said for the past several years, that it's a civil matter between the person towed and the tow truck company. So if a person who's towed feels that they've been charged too much, then they can file a small claims action. And it was my understanding that the Center for Student Legal Services, who represents college students, did file a couple cases in municipal court, but those were never decided on that specific issue. So that's where we are today. And I thought I would turn it over to the chief to explain his position in regards to regulating tow truck operators.
Yeah, is this okay to be here?
Sure.
So I might be able to catch council up on how we arrived to today. The Ohio legislature passed the law putting towing regulation or towing fees and whatnot under Public Utilities Commission in the mid-2000s. I don't know the year, maybe the law director does. But it was common understanding that that law essentially stripped municipalities of regulations and setting fees. And so the city of Athens, acting on that information, really did nothing to repeal our regulations on the books because they were essentially nullified under our understanding by the law that placed towing under PUCO regulations. And then I think there was, again, I don't know the year, but I want to say it was around 2015, there was a court case decided that set case law basically saying that no, municipalities could regulate towing if they chose to do so. But by that time, we had about 8 or 10 years of allowing tow truck operators, both in private tows and public tows ordered by law enforcement, to follow the PUCO guidelines as far as fees. And so, and in actuality, that case law was decided. We didn't learn about it in the city until a couple years later, and I think that was around 2017. And so it was then that law director and I began to have discussion about repealing our regulations and allowing PUCO to actually be the fees charged both for private tows and for public tows. And we're specifically talking in our parking regulations or our towing regulations about public tows, tows ordered by law enforcement. Everything else is in fact governed by PUCO regulation. And so I think we had several back and forths with council between 2017 to 2019, and then in 19, right before the pandemic, we sat down and crafted some law, put it before council, and it just didn't get acted on, I think, because the pandemic struck in early spring of 2020. And so we really hadn't dropped it. We're just waiting for an opportune time to bring it before council again to act. But the truth of it is that the fees need to be updated in some meaningful way, or based on our recommendation, the fees are simply referred to in our code as what is established for private tows by PUCO regulation, And anytime the state changes those regulations, our regulations would automatically change as well. And so that seems to be the most efficient way to handle the the fees, the towing fees. And in fact, if we chose to utilize a tow fee that is in some way less than what's established by PUCO for private tows, my fear is that we wouldn't get a wrecker anywhere in the region that would tow for us. And so we wouldn't be able to tow vehicles that are in violation of parking ordinances and whatnot. So we at least have to fix those fees to either match PUCO or just as the ordinance in front of you states, just simply refers to the PUCO regulations and whatever fees are found in those. As far as the towing regulations, we decided, this was a more recent decision, as we were reviewing that section, I had suggested to the law director that in fact we haven't regulated tow trucks for pretty much my tenure as at least as captain to today, which I was promoted to captain in 2004 and chief in 2011. Had no involvement with regulating tow trucks, and in fact didn't know that the service director's office or the code office wasn't regulating tow trucks until we started discussing this in 2017 or 2019. But somewhere along the line, I became aware that no one in the city was regulating tow trucks. And that, by the way, predates everybody here. I'm not sure why the city dropped the enforcement of the regulations, but we have no record of enforcing those regulations. And so it's our recommendation in reviewing that we remove the regulations. We talked to the service safety director, the mayor, the law director, the auditor, code director, and myself, and none of us have a valid reason to continue to regulate tow trucks when PUCO, in fact, has all of those things in place for regulations. And it is a business that can be, as the law director referred to, disputes can be handled in civil court and things like that. And so it is, again, our recommendation that we remove the regulations in their entirety and just simply refer the towing fees to the PUCO regulations that the state sets. So that's pretty much where we are in a nutshell.
Okay, so that, I'm looking over the draft of the proposed ordinance, and I see it's basically, we strike out everything that's in chapter 7.05 and insert a few lines referring to the Ohio Revised Code for the PUCO fees and regulations.
Yes, off the top of my head, there are three different fees. There's the actual towing fee, there's a storage fee, and then there's a hookup or show-up fee. Mm-hmm. And those are set for private tows by PUCO, and we simply just refer those three fees to what's established by the state of Ohio. It's a clean way of handling the business of towing fees.
So if this ordinance goes through, and we're mostly referring here to the private tows, what about when the police have to call out a tow truck to, remove a vehicle?
So that shouldn't change, and the wrecker operators, as they do currently, they charge the PUCO fees. They do not charge the antiquated and non-updated City of Athens fees. They charge the PUCO fees. Mm-hmm. And so technically, as far as the fees concerned, nothing increases, nothing changes. Those wreckers are already charging those fees.
Okay. Questions from our committee here?
I have about 100 of them.
Well, you've got 10 minutes.
I think 24,000 citizens of Athens would certainly want us to take due time on this. I live over on Townsend, and let's say that I get up one morning and I can't start my car. And I call a tow truck operator to take me to my preferred mechanic, Alvis, out on Columbus Road. Any idea what that charge would be? No,
and that's not a fee that would be regulated by PUCO in this instance for either private tow or that is a customer business person decision.
Understood.
Yeah.
But from my house to Alvis is about the same as my house to Curtis Towing. And if a tow truck driver would make that haul for $79, I don't think we're really going to have a problem with tow truck drivers not taking tows for less than $129.
I would disagree. I think my fear is if we don't allow them to charge other than the antiquated fees in the current code, we'll not get a tow truck driver to work for the city of Athens on public tows. That's my personal opinion.
One of the parts that troubles me in this is that we license and regulate just about everything in the city. Food trucks, plumbers, electricians, beer manufacturers. And those licenses are for the good health and public safety of the citizens of Athens. In .601 B2, it says, if a municipal corporation requires tow trucks and tow truck operators to be licensed, specifically giving the municipality the right to do that. I can't imagine having unlicensed vehicles hooking up and hauling away $40 and $50 and $60 and $90,000 cars. Now, granted, there are certain things that they have to do with PUCO, but in a city that could certainly use some additional revenue and some local control, it would seem logical to me that we would also license them here.
Well, you're describing something that hasn't taken place for at least 18 years, and I think the law director referred to 25 years. So the city's functioned without licensing or regulating tow trucks for at least that long.
And because of that, when I called PUCO, Mr. Bradley Long, the director of towing for PUCO, he can name the tow truck companies here in Athens on a first-name basis because of the number of complaints they get. I think if we can regulate this at the local level, we have a better opportunity to control it. For example, the after-hours fee can be up to $150. By PUCO rules, the towing company must be open from 9 to 12 every morning for people to pick up cars. So if I get towed and go out there at 10 o'clock at night, the current practice is to charge me $150 because that's after hours. But if they have tow trucks on the road at that time, according to Mr. Long, they are open and are making illegal charges of $150. If we have licenses here in town where it's easier for people to report that, then we as a municipality can regulate that and revoke licenses that are abused, revoke licenses that are not followed. So I'm a big fan of keeping licenses local if we can. Now, I could go on and on and on, but in deference to the 15-minute rule that first I've heard of, I'll let it go for there right now.
Other members of the committee? Member Ziff.
Thank you, Member Reisner. Yeah, I personally, I don't really like using the idea that because we haven't done this in a long time, we don't need to. That doesn't feel like a real justification to me. That feels, not that I'm calling anybody this here, I know everybody's very hardworking, but it feels lazy to me. It feels like lazy legislation. And I agree with Member Swank. We license all kinds of things, almost everything. You have to have a license because it's for, like he said, the good and safety of everybody around here. And just because we haven't done it doesn't mean that we shouldn't do it. You know, we never had a mask ordinance ever, and then we had one because it was for the good of the people in this town. So that's where I'm at.
Member Grace, anything?
No comments at this time. Thank you,
Okay.
Member Reisner.
Other members of City Council? Member Spionis.
I think this is more than just about fees. It's about making sure that we're careful about not taking advantage of folks who maybe had a problem, their car got stuck. There's other issues that people have. So I think regulating is an important part of, as has been said previously, protecting the citizenry and making sure that we're handling things in an appropriate way. And I too have heard, as everyone else I'm sure has too, the number of complaints about how it's done. Now, nobody wants to have their car towed, and of course there's legitimate reasons for having your car towed. But I think that reading through the regulations that apparently haven't been followed, I think there's some there that are very important, irrespective of the fee. So I think, again, this is much more than just the fee. It's how it's handled and processed, and that we have a system that's fair and makes some sense. So that's.
In response to your comment about PUCO and their constant complaints, my department's not aware of that, and I'm not saying it's not true. I'm saying I'd like to know what PUCO does with those complaints, because it's been our impression the entire time that they were regulating towing, which is the entire purpose of our recommending this repeal. This was akin to Lyft and Uber and the state law that was passed saying that municipalities cannot regulate them. Well, they're functionally taxis serving in the city. They call it rideshare, but for our purposes, our regulations of taxis went away because they all started calling themselves rideshares, or simply went out of business because they couldn't compete with a state-regulated service. And so when we looked at this, the first thing I referenced was the state passed a law saying we can't touch regulations for Uber and Lyft. How is this any different? So I'm very curious to know what PUCO does with those complaints. Apparently they just ignore them. Is that what they're saying?
I could follow up, and I'd be more than happy to follow up. I've got Mr. Long's phone number and email here, and call him in the morning to see.
Yeah, it just strikes me as odd that they have this laundry list of complaints, and the city of Athens hasn't heard a single word from them about it, And had we, I bet we would have been hesitant to make a recommendation like this. So, this is new information to me.
I'll get it to you as soon as I can.
And then I have a question for Member Swank.
Yes, ma'am.
When you were talking with Mr. Long, did you ask his opinion on the city charging rates that were less than PUCO rates?
Yes, what he referred me to, and again, we're talking about two different,
Sure.
well, .60
And 601.
601. And what he referred me to in .60 is B. However, if the vehicle was within a municipal corporation and the municipal corporation has established a removal fee, you have that right to do what the traffic will bear. And take it a little step further, he said, if the vehicle was towed with a municipal corporation that has established fees for vehicle removal and storage, again, he pointed me to both of those. But he also made it very clear that only pertains to vehicles left on private residential or private agricultural property, not the private tow zones.
And so for those private towaway zones, he agreed that the fee would be a fee set by the PUCO?
Yes, ma'am.
All right, thank you.
Yeah, and
He also did, I'm sorry, one other quick, he also pointed out that in 2021 and 2022, that most of these are up for a 5-year review.
That's
And in
right.
my research of the state legislature, that review has not even begun yet.
How surprising.
So it's important to clarify that we're not just talking about private tows, where, a lot of the lots that are signed and posted, those lot owners contract with private towing companies, and those are the fees that are established specifically by PUCO. It's very rare for an agricultural or private landowner to have a vehicle towed because of, nobody really just drives up to somebody's driveway and parks in it and walks away from their car. It does happen, don't get me wrong, we do get complaints, but typically they return to the car and drive away before the 4-hour mark and tow takes place. And so it's very rare that we have those kinds of tows from private agricultural and residential. And so PUCO is saying, yes, we can establish a fee for that. Our point would be, why would we? It's the same fee. It's really no different. Towed off of a signed contracted lot or towed out of somebody's yard. The PUCO can set those fees. The other tow we're talking about, specifically the ordinance that's in front of you, deals with specifically police ordered tows off of public property. If I order a car towed as a police officer off of a yellow curb or parked in front of a fire hydrant, those are the fees that we are referring to PUCO. You follow me? The tow fee that you've referenced in, towing your car because it's broke down to the repair shop is not referenced in any of these regulations. And those fees are not set. That's just a business decision that you would enter into with a wrecker. And a person would be free to call as many wreckers as they chose until they found a fee that they liked. The only thing I can say in response to that comment is if a wrecker is allowed by law to charge something, my guess is they would charge that.
Exactly.
Member McCary, I saw your hand.
I was going to ask this of the chief or safety services director, but what would have to change in order for us to have the capacity to regulate this locally?
Well, the current laws that regulate towing really has to do with licensure and insurance, if I recall correctly. And so I don't know who, currently it falls under the purview of the service safety director, a service safety director at some point. And I'm guessing this would be back in the Ron Chapman, Wayne Key days, made a decision to either farm that work out to another department in the city or just not do the licensure. Like I said, I took over as the captain in the police department in 2004, and we were not doing anything with licensure and towing regulations. So it predates everyone in the administration. And I'm not certain, except that the service safety director's office would have to review it and probably assign it. And I don't know if they'd assign it to code, but we'd have to establish new provisions, obviously, and we'd have to follow the existing code, which, again, is something we haven't done for a number of years. And I really can't answer why we don't do it, just that we don't.
Member Crowell?
Thank you, Member Eisner. This is a question for the chief or the law director. And just as for clarification for myself and for the public, we've had people come before this body and say that they met the tow truck driver at the location where their car was being towed, and the tow truck driver towed them anyway. If I understand correctly from reading your opinion and looking at the Ohio Revised Code that you cited, that is illegal. That if you show up before that car has been removed, then they are required to charge you half of the $129, and you get to go on with your car. Is that correct?
That's correct.
That is correct, but you also have to pay it.
Yes.
And a lot of times the people refuse to pay, and so the wrecker does take off with the vehicle. And a lot of times they call us to come and try to mediate the dispute, and our response is you have to pay the person this fee, or they're allowed to take your car, which is more money, and then there's a storage fee, and then a show-up fee, or a late pickup fee, as you say. All that is regulated, yeah.
Yeah, I did see that that's very specific in the code that you must pay, but I want to make sure that that was correct. Thank you.
Yeah.
Madam President, you have a question?
I do not. I am looking at the clock, though, realizing we've
Okay.
been almost a half hour, and this is only our first agenda item, so I was going to ask you, yes, I
Yes.
guess I will ask a question. What's your next step?
Well, my next step is, having given all members of City Council a chance to speak, and the police chief and the law director a chance to tell us what all this is about, which I think is due diligence when trying to look at this thing, I'm going to open it up to public comment. Give us your name and your address and whether or not you represent a group.
Damon Crane, Hudson Avenue, not representing any group. For the past several years, APD and city administrators have been pushing council to repeal the towing regulations currently contained in city code. Council hasn't repealed the regulations, so the administration has just refused to follow them, thereby recklessly refusing to carry out duties expressly imposed on it by law, something Ohio Revised Code 2921.44 defines as the criminal offense dereliction of duty. The administration's justification, which Director Stone emailed me last fall and various officials stated at a 2019 council meeting, is the council has no legal authority to regulate towing operators, or in the version that Director Eliason put forward tonight, enforcement can only be handled through civil lawsuits. The problem is that's not what the Ohio Supreme Court said in Cleveland versus State 2014. That's not what the General Assembly says in the Ohio Revised Code, and that's not what PUCO says. It's absolutely false, and the truth has never been difficult to discover. As Caleb Brown reported in his 2016 Athens News column, as former OU Student Senate member Adam Boesinger reported to Council in 2019, and as I reported in my 2021 Athens News column, the Ohio Supreme Court made clear in 2014, and the General Assembly followed suit in 2015, that municipalities have the legal authority to regulate towing, including the right to license operators and set fee caps different than those set by the Public Utilities Commission. Many Ohio cities have been doing exactly that ever since, and as far as I can tell, we're the only city that's ever suffered from this confusion. In fact, after the Athens News published my column last November, former reporter Cole Behrens, who's now with the Columbus Dispatch, decided to call up PUCO and see what they had to say. PUCO spokesperson Matt Schilling confirmed what Caleb, Adam, and I had reported and refuted Stone's and Eliason's claims. Before Cole could publish his interview, the Athens News lost its entire news staff, but Cole forwarded me his notes and gave me permission to cite them here tonight. Cole's interview probably took 5 minutes. My column took a few days of research. That's it. Yet for the past 7 years, the administration and law department have continued to make these false statements. This has caused enormous harm, especially to low-income residents disproportionately impacted by the 24-hour parking rule and its selective enforcement. Here's a conservative estimate. Suppose that since 2015, each of the city's 3 towing operators have towed just 3 vehicles from city streets each day, 6 days a week. According to code, they overcharged everybody they towed at least $80, which according to code made every one of these tows illegal, which according to code mandated that Director Stone revoke the operators' licenses. The city administration then, by refusing to carry out its duties expressly imposed by law, has enabled the illegal transfer of roughly $2 million, most of it coming from the pockets of low-income residents. And that's just towing from public streets. Law Director Eliason cited ORC 4513.601, but as Member Swank cited, that statute states if a city requires tow truck operators to be licensed, and our city code does in fact require that, no owner of a private property shall cause the removal and storage of any vehicle by an unlicensed operator. That means all towing that's occurred from private property in Athens since 2015 also has been illegal, and the administration's dereliction of duty has illegally transferred even more millions of dollars. Please don't become complicit in the administration's wrongdoing by repealing these regulations.
Thank you.
Thank you.
Well, if that's all the comments, then this topic's closed. We'll move on to our next. Municipal Bridge Projects Application. And I received some email from our assistant engineer, if I can find it here. Let's see, here it is. The application is submitted to ODOT. The Municipal Bridge Program provides federal funds for bridge replacement or bridge rehabilitation projects open to vehicular traffic. The funding limit is up to $2 million per project. If awarded, ODOT contribution would be 95% of construction costs for a project considered during state fiscal year 2024-2025. Application period opens July 1 and is due August 15. The annual bridge evaluations are being completed, and 2 bridges are expected to be eligible for funding, and it's noted here, Stimson and Dairy Lane Bridge. Would the Service Safety Director care to comment on it?
I can speak a bit further on this. The
Great.
Digital Bridge Program is a program that we've used several times in the past, both of the large bridges on Richland Avenue, the bridge on Carriage Hill Drive, and then also the bridge across the Hocking at Union Street are all programs that were funded through this particular program. Right now, it's 95%, 5%, so that's a pretty good deal. That has to do with toll credits that are still available. When I say toll credits, it's state money available from bonds issued against the turnpike that they're using for bridge improvements across the state. So that an extra 15% of the match. The 2 bridges that are eligible have to do, or what we believe will be eligible, have to do with their general appraisal, and that's a 0 to 9 scale. And when bridges are 4 or less on that 0 to 9 scale, that means they're eligible against the municipal bridge fund. We anticipate Stimson Avenue is probably the project that we're going to go after because that would be a large scale project that we would need these federal funds to do. And assuming it comes up as a 4 on that general appraisal, that would be the project that we would apply for. the ordinance that we would ask you to pass allows us to apply. In the past, it hadn't required legislation, but ODOT has changed that in recent years, and now to apply, you have to have an ordinance.
I see. Questions from the committee?
Would the
Member Allen.
Yes, would the Stimson Bridge be part of the ODOT reconfiguration that you sent me today?
No.
Two separate projects?
Separate projects. This is
Which would you envision coming first, the ODOT?
The ODOT project, yeah.
Okay.
This won't be until fiscal 24, 25, or state fiscal 24, 25 timeframe, so. This is a city responsibility bridge. There's a series of bridges in the city that are ODOT responsibility. And I can kind of go through and mark them for you. Most of those fall on the US 33 and 50 system, and then the interchanges supporting that system. However, there are several bridges on city streets that are purely city responsibilities, and some of the ones I mentioned earlier on the municipal bridge program that we've used in the past are some of those, and then Stimson is another one that we have responsibility for maintenance on.
Other members of council? Questions about this application? Okay, well, thank you. We'll go on to the next topic. Oh, what? Oh, member of the public, yes. Please, speak.
Begrudgingly, yeah. Rob Delac, live on Morris Avenue here in the city, representing myself. I'm just curious if this kind of project is a
Oops, sorry.
rehabilitation.
Time's up.
That was the quickest one.
Is a rehabilitation project just to sort of resurface or something like that, or fix the beams maybe, or if it's a rebuild kind of project? What do you anticipate?
What I anticipate on this, I mean, if I could address it directly, what I anticipate on this project is it's probably a redecking, some improvements to the abutments and the back walls on the abutments. I think the bearings on the eastern side need reset, and a couple of them need replaced. I believe the beams themselves are in good enough shape, although there'll probably be painting associated with that. But my gut feel is it's going to have to be a redecking, not unlike what we did in 2010 for the Richland Avenue Bridge over the Hockey River.
So do you anticipate, here's where I'm going, you probably know, is do you anticipate the possibility of reconfiguring the bridge so it's safer for pedestrians to cross?
Sure,
That's what I have in
absolutely. I
mind.
mean, that would be a goal of a project like this. Granted, there's nowhere necessarily for pedestrians to go at the moment when they're walking that direction, but that's no reason not to do it because.
There's a lot of them that go that way.
I recognize that there is a location, there's not a city location. But we anticipate in future years, as the city grows, there could be legitimate locations for pedestrians to travel to on that side of the river, and we would absolutely design accordingly.
All right, thank you.
Any other members of the public care to speak on this topic? Okay, now proceed. That was a good one, I like that. Ohio Public Works Commission, issue 1 funding application. Administration, care to speak to that?
Every year we apply for issue 1 funding through the Ohio Public Works Commission. Our region, with the Council of Governments at Buckeye Hills, basically sets the criteria based upon the Executive Committee's point valuation system. And then we've been successful in past years getting funds through this. I think the most recent one was the Simpson project, project number 315, had $400,000 of both grant and then another $400,000 in loan against that project. This almost assuredly has to be a transportation project, even though you are able to apply for utilities projects as well. From Ohio Public Works Commission, the structure is such that they really aren't competitive when it comes to points. And so we don't have to specify what project we're going to apply for, but the application is due 31 August. And since council will be on recess in July, this will allow us to submit an application. We'll go ahead and get reading started now. That's what we're asking.
Okay. Members of the committee, any questions? Members of council? Members of the public? No? Okay. All right. Last topic, West Washington Sidewalk and Safety Improvements Project number 335. And I have an email here. Says the project includes spot sidewalk repairs on West Washington Street between Schaefer, and Lancaster Street. The project also includes vegetation management to remove vegetation impeding the sidewalk and visibility of streetlights. Lighting improvements are also being reviewed. Care to comment?
Yeah, that pretty much sums it up. It's an area that is dark, not because there's a lack of lights, but because there's a tremendous amount of vegetation that has grown over the street. Additionally, some of the sidewalks are in pretty bad shape. This really focus is going to be on the north side. There are a couple instances where we've got some slips on private property that is impinging the sidewalk, so we're going to have to work through how we're going to have to manage, repairs in that particular location. But by and large, this should make a pretty significant improvement. Of note, the appropriation and authorization already is in place, but this allows for us to advertise, accept bids, and enter into contracts.
What would be the length of this? Are we talking about several thousand feet?
These are spot repairs, so, this is not, whole, ripping out and
Right.
and replacing. I would say if I had to estimate about 1,500 feet,
Okay.
of spot repairs in that 3 or 4 block section.
And would this make it more ADA compliant?
It would. Now the roadway itself is steeper than a 5% grade in some places in
Yeah.
a particular area. So, but insofar as making it better than it currently is, particularly on cross slope in some of the really bad sections, I think it'll be much better.
Members of the committee, questions? Other members of council? Members of the public? Oh, come on, this is sidewalks. Oh, well, all right then. Well, that concludes transportation.
Thank you very much, Councilmember Reisner. We'll now move on to Planning and Development Committee. This is chaired by Councilmember Grace and joined by Councilmembers Crowell, McCary, and Spielness. As people get seated in their various spots, for this first item, we are considering a special use city right-of-way permit. This concerns 2 ordinances that were approved by City Council in April, 3622, 3722. And then last week, we did receive a formal request from the Myers family to reconsider the approval of 3622. So, Councilmember Grace.
Thank you, President Isley. And yes, as President Isley stated, this is on the agenda this evening at the request of the residents living on May, asking that we reconsider the granting of one of those 2 special use city right-of-way permits. And our normal flow here in council is for members of the committee to discuss, then other members of council, then the administration, and then ask for input from members of the audience. But in this case, because this has already been discussed and voted on in council and is brought back at the request of the community, I believe it's appropriate to start with hearing from members of the audience who are here to speak on this topic. And so I'm going to open the floor up to that, but keeping in mind that President Isley will be utilizing her time clock. So if there are individuals wishing to speak, yes, please come up to the podium and give your name and address, and if you are here representing a particular organization or group.
Hello, I'm Megan Gallagher-Meyer. I'm not representing a group, and I live at 89 South May Avenue. If it is appropriate, I wasn't sure, but we put together some informational packets for every council member, so if I would be allowed, I'd be happy to pass that out. I also submitted them to Ms. Walker prior to 5, but very closely prior to 5 today. Is that something I'm allowed to do?
That's fine.
Yes,
Okay.
that's fine.
Would you like me to speak while I'm doing that? 'Cause
You probably should, because I'm not good with this timer.
So I told you
It's
who I
ticking
am.
down.
We are here to talk a little bit about the simultaneous granting of 2 ordinances, 3622 and 3722, that were granted through, you don't need to read this one?
Yeah, actually, she does if you have an
She
extra
does.
copy.
Sorry.
Thank you.
I might have not. Hold on for you. Sorry. So for the past few weeks, we've been trying to get some clarification on what these two simultaneous permits really mean for us. And just for a little background, there's a lot of information in there. I'm just going to summarize along with my husband. We met with Code Director David Riggs in December of '21 after learning of the Montel LLC's plan to use our dead-end alleyway behind our house as an access to create parking for a new rental property behind our home. We made it very clear in that meeting to Mr. Riggs and to Mr. Montel that all neighbors at the meeting were against the use of the alleyway in this way. We had, in addition, had 2 other neighbors that signed a petition that are here today who were not able to be at that meeting but said we are opposed to the use of this alleyway. Our understanding is that this information was not shared with council because the letter written to City Council from Mr. Riggs dated February 9th makes no mention of any neighbor opposition. Mr. Riggs also recommended that both applicants be approved to you in a February 9th letter when we've seen the application that Montel LLC put into the code office, and that was not dated until February 18th, after the letter was written to you. In addition, we've looked at the map that was given to City Council, and there are no dimensions listed for the alleyway, no markings referencing where a car should park, where the sidewalk extended to, and who received access to what land. It's our belief that if more information regarding the actual space was given to City Council, they would have understood that granting access for both permits makes no physical sense. Finally, we feel that since the passing of our permit, we are being told different information. The photos that were submitted with our application, which are in the packet for you to see again, show a sidewalk and a parking space. These were listed as part of our approved permit, but now we are being told that we need to park our car on the sidewalk farther into our property, into a very narrow area that we would not be able to access the passenger side of the car. The opening of the driver's door would be inches from my mother's home. This was communicated to us not until May 4th. So given incomplete information, we feel that City Council could not have made an informed decision when they passed these 2 permits. The result of this is an unmanageable and an unsafe situation. We ask that the committee reconsider our situation and that this does not remain the final decision by the City Council.
Is there anyone else who wishes to speak?
I am Leonard Myers here last week. I'm here to talk more about safety. The simple reason that we had never acted on this prior was that anybody familiar with this area would realize that this would be an unsafe situation to ever allow vehicular traffic through this tight space. In short, we never believed that the way the area had been governed for 50 years could possibly be threatened. The situation just seemed unimaginable to us. The Agnons, who owned our home from 1948 to 2012, built this structure, which is my mother-in-law's home, over 50 years ago. If the city at that time allowed a front door to be placed on an actual alleyway, then we believed that it would have been an impossibility to open up this space, in particular for vehicular access. Imagine vehicles driving within 4 feet of your bedroom window and essentially on your front porch, passing within 4 feet of your front door. Even dense urban spaces have several feet of sidewalk as clearance for a front door. Not only is this a major disturbance to somebody's right to live peacefully, it is basically a tremendously unsafe issue. In addition, the sidewalk that we paid for and had installed is not a sidewalk to support vehicle weight. There will be a major utility pole that is being proposed to be moved from its current location. It would require vehicles to travel between that and through an area that's about an 8-foot space to access the South Shannon property. Newer vehicles are sometimes wider than that space. In regards to safety, we feel that this is a disaster waiting to happen. As evidenced by the shared opposition of all adjacent resident stakeholders, this does affect more than just my family. Other children access the alleyway to go between relatives' homes, and although rare, children do occasionally play in this area. Vehicular traffic in this space does not enhance the safety and well-being of this community, which is the language to be changing this. There's a great deal of concern regarding the precedent that this could establish regarding opening up access further and further down this alleyway, all the way to Hughes Moakland. And there are neighbors further down the street that are also concerned about this. We think that other options are open to the developer, and in particular to the South Shannon property, and we feel that the established peace and well-being and safety of longtime residents outweigh that interest. I know we are not using the same standards that the Board of Zoning Appeals use, but they use the line, will the granting of this variance be in harmony with the general purpose and intent of the zoning ordinance, and will it be injurious to the neighborhood or detrimental to the public welfare? In this light, we feel that opening up this alleyway to the neighborhood is detrimental to our public welfare, and we ask you to reconsider.
Hi, I'm not representing any group. My name is Kelly Madewell. I've owned 85 South May Avenue since 2003. In those 19 years, the alley behind my home has been a calm and quiet space shared by my neighbors with very little traffic. There have been no problems, and I've given it little thought. My kids start bike rides in the alley. They walk to their grandparents' house through the alley. I use it for unloading mulch, etc. I was surprised to learn about the proposed change, which would significantly change the use of the alley. The Athens, Ohio Code of Ordinances states that the criteria for a right-of-way permit is that it will contribute to the public health, safety, or welfare in the city. It would be difficult to argue that this change would meet this criteria, as it would clearly have a significant impact on the activity and safety of this area. I'm opposed to granting access through the alleyway to the new home at 72 South Shannon. Thanks.
Art Ostrike, 91 South May. We bought this house at 91 South May, and there was a revocable easement in the alley set up by Mr. Doug 80 that I'm sure some of you remember. And they renewed it once, and I was planning on renewing it again next year. It's part of why we like that property. It's got a fenced-in yard. We were 2 months from our first child at the point when we bought that property, and now that Wilford is 4.5 and starting to move towards those bicycle rides and starting in that alley, we'd prefer not to have a road there either. I also am just a little annoyed. Like, usually I call a number of you for different things and ask questions on how to move forward with different projects, right? And with this one in particular, we made the phone call, we set up a meeting, a number of us were there, and we walked away from that meeting saying, okay, great, this can't be a road, it's got to be a curb cut. And there was a city official at that meeting, the right person to talk to. And here we are. A little confusing as to if the phone call that I make is the right phone call to make today. So that's another reason why I think we reconsider and talk about this. So, thanks.
Hi, my name is Keely Holtz. I'm not representing any party. I reside at 73 South May Avenue and am also the property manager. In addition to the safety concerns that everyone else has spoke about, I want to know who is going to maintain this alleyway. This alleyway is already not being maintained. It's basically like a dirt path with grass and gravel on it. And if we have more access than it's already being accessed, I feel like this alley does not support it. And especially if there's going to be a build right down the alley and the construction vehicles coming and going from this alley, causing ruts in the alley. I already have a small gravel drive in the back that's already hard enough to access because of the small size of the alleyway. I just feel like it's just going to break down the alleyway where none of us are going to be able to use it. So that's my question. Who's going to maintain it? Because it's already not being maintained. And before making this decision, did anyone go and look at what the alley looked like and whether it was accessible for this kind of additional usage? Thank you.
All right, yeah.
Comment be permitted after council speaks, as is typical?
Yes, I think that we could allow that. Sure. And so are there any other members of the audience who would like to speak at this time? Okay. I appreciate and understand 100% all the comments and concerns that have been brought here this evening. However, the back of my property abuts a city alley that does not go all the way through to the end of the city's right-of-way. So I understand, like, my access to the parking behind my home is off of a city alley. And regarding the maintenance of it, I called the city streets department and said, hey, would it be possible for this alley to be graded? And they actually came right over very quickly and graded and put down rock, because the city does do that for city alleys. So just you can call about that. But the purposes of the city alleys and right-of-way is to provide access to all properties that abut that city right-of-way. And while I do understand that your current uses are what have been the uses for quite some time, everyone who lives up to and as far as 89 South May has been using the alleyway for access to the backs of their properties. And I disagree with the fact that people closer to the road access therefore have greater rights or privilege to use that city right-of-way permit. And it was my understanding from the opinion provided to us by our Director Riggs was that there were 2 property owners who had applied for or were applying for permits to use the city's right-of-way. And as members of the city government, we have to consider the rights of both property owners to access the city's right-of-way. And if the primary purpose of an alley or a right-of-way is to increase access to property, then to allow what is already in existence closer to one end of the alley to prohibit access farther down the alley does not seem like a fair application of use of public right-of-way. So that is my position on this as chair of the committee, and I would like to open it up to other members of the committee who have thoughts or comments. Yes, Member McCary.
Thank you, Chair Grace. I am understanding this to be a conflict between access and safety to at least some extent, and I'm just curious procedurally, if we were to reverse this, what actions would that require? And when? Yeah.
Well, we could, an ordinance could be introduced to revoke either or both of the permits that were granted in April. And so that it would be an ordinance to, and it is, it would depend on what the ordinance was drafted to do, whether it revoked one property owner's permit to use the public right-of-way or both property owners' right to use the public right-of-way.
And that would require a motion tonight, right?
No.
No.
Our next regular council meeting would be when the soonest that an ordinance would be introduced. So we're here to discuss this in committee, but that would be the legislative action needed to revoke a previously granted permit.
Okay. But no one on the committee would have to move to suggest that ordinance?
No, not tonight.
Okay, great.
No, someone would have to choose to introduce it for first reading next week.
Thank you.
Or 2 weeks from now.
2 weeks.
2 weeks from now, at our next regular meeting. There. Yes. Are there other comments from the committee? Member Crowell.
I just really have a question, and I know our chief of police has left, but, and our law director, but we just had the question about towing and where from a public, and this is not a situation that is clear to me. We refer to these often as paper alleys, and this alley in particular, I think there are alleys in the city that really have no access at all. And this one does have access from Lincoln down to the, to this point. But does anyone know, do you know, Member Grace, if you know, I park in one of these alleys, does the law say that I should not be parking there? Can I be towed for parking in a paper alley?
I don't know for sure, but I would guess so, because it is a city right-of-way, so if you do not have a permit to use that space to park there, then yes. But that's not a legal opinion, obviously, that's my guess. Yes, go ahead.
That's correct. And typically those are complaint driven, you know, as opposed to patrolled and towed. You would just search for somebody that happened to be parked in one of these. But if there was a complaint and it was public property owned by all the citizens of Athens and they were blocking somebody else's access, then yes, you know, that would be a spot that could be towed.
May I follow up?
Yes, go ahead.
Maybe Director Stone can answer this too. In terms of a curb cut was mentioned. Are there any safety concerns, or are there any, when a property owner requests a curb cut, for example, here on Shannon to access these properties, is that something that's reviewable by the code director or by your office in terms of a safe, whether it's a safe place for a curb cut?
Sure. So our code requires an opening permit to access a public right-of-way, which is commonly referred to as a curb cut, and that's entitled Title 9, I think, is where the general regulations, and they talk about that somewhere in Title 9. But our process right now is there's an application submitted to the code office. The code office lets the engineering public works office take a look at it for geometry and what they're proposing to do from a you know, surface perspective, and you know, if it's complex drainage or something else, and then ultimately it's my approval to grant the curb cut.
Thank you.
Are there any other questions or comments from other members of the committee? Okay. Are there comments from other members of council? Yes, Member Swank.
Scott, were you able to get that slide up by chance? Okay, I think I've got a solution. Members of council, if you refer to the brochure that the Myers passed out, page 2. Where we're talking about is over on the Near East Side. This is May Avenue, South May Avenue. This is South Shannon. That's north. Super America's up here. This street right here is Lincoln. Those of you who are regular attendees at the library's down here. So you have an idea where we are. At the present time, Mrs. Meyer's mother travels down the alley and parks right there. Mr. Montel wants to build another quality home right over here. The initial idea...
Next one down.
Yeah, next one down. Yeah. The initial idea was to grant access to this property down the alley. This would involve coming within a few short feet of this house. I was first notified of this issue on May the 6th. Got a text from Megan, are you available at 11:15 to have a phone call? We had a phone call. I'll have to admit at this point in time, I feel that council, myself included, made a serious error in passing this at the first time. We made a mistake. I think it was an honest mistake, and it was an honest mistake because of a lack of information. We could stand here today and point fingers here or there. I don't think anybody wakes up in the morning and says, I'm going to screw up today, or I'm not going to tell the whole story. I don't believe that. I don't believe people do that. This was an honest mistake in communication. Stupid. This past Friday, I met Mr. Montel at the property because we're trying to talk about this on the phone. I've been talking to Megan in the restaurant. You needed to be on site. And Mr. Montel, correct me if I'm wrong, but he and I came to the conclusion that coming down this alley with cars on a regular basis was probably not in the best interest of anybody when we finally got out there and looked at it. when we finally got out there and looked at it. Because it was described to me earlier, the cut was gonna kind of be like this across the neighbor's property. Because I went out there to see this, and if you remember, and you can watch the videos, I was the biggest advocate of this thing happening. When I walked down the alley, Mr. Montel was standing there like this, and I'm entering from the other side, and I could tell he was deep in thought. And some of the first words out of his mouth is, "This probably isn't gonna work." So we walked all the way around the property and determined that yes, indeed, we could do a curb cut here, because every one of these houses on South Shannon has a driveway entrance. That curb cut would come at an additional cost to the developer. If you've looked at any of his properties, he produces and builds quality property, and Lord knows we need good quality housing in this town. So what we would do, and what the proposal would be with this, and we'll have to run this by Mr. Stone and Mr. Riggs, is that on this picture right here, where that stake is, which is right there, that's the property line, we would vacate the alley. The city, and this would have to go through council, would vacate the alley from that point all the way down to the end. Now what does that mean? The property owners on this side get 5 feet, and the property owners on this side get 5 feet. From Lincoln to that point, the alley is still accessible. And when I spoke with Megan, I asked her, could your mother park on the pad next to the house? And she said, yes, she could. When you look at that first picture there, there's a pad right there. Your mother's gonna have to walk a little further. But what does this do? This allows Mr. Montel to build his quality house. This allows, I don't know what your mother's last name is, but Megan's mother to come down to her house and park. And the nice thing is, everybody, including Art, gets 5 more feet of land.
I just gotta build a new fence.
I will come over and help you move your fence. You only have to move one side.
Right.
But that's what it would involve, and Mr. Montel would have all of his property rights. Again, we made a mistake, in my opinion. I accept responsibility for that because I was the leading cheerleader of the original idea, but we didn't have all the information. And I feel that too was an honest mistake. So, Madam Chair, I don't know how we go from here, but my recommendation would be not to throw the baby out with the bathwater, but to vacate the alley in a manner that's most expedient, allowing everybody to maintain their property rights.
Okay, it is my understanding that the city is very careful in any consideration of vacating right-of-ways, because once the city vacates a right-of-way, we can't get it back other than through eminent domain, which we know is not a popular process. Just 1 minute. And so I would like opinions from Director Stone and Director Riggs as to whether the same plan could be accomplished, but through adjusted right-of-way permits, use permits, rather than like to continue to grant a right-of-way permit to allow the residents to use the city right-of-way, many of them as they are currently using the city right-of-way, without the city vacating the alleyway. One, I think that's a longer process. And so that is, do you have any comments on that, Director Stone? I know.
A couple comments. Number one, in Title 49, the right-of-way legislation, City Council was very directive when that legislation passed that the body wanted to maintain authority to grant special use of the right-of-way permits. And that's why this whole issue arrived in your lap as opposed to being an administrative function. And we in the administration find ourselves from time to time in the middle of circumstances where neighbors don't necessarily agree with land use of the adjoining neighbor. In this instance, it's public property with an alley that's owned by all the citizens of Athens. Certainly, you could go in there and draw, very particularly even with a survey, maybe to say that a permit could be granted this way and a permit could be granted this way, and then that be like a revision to the permit. To your point about vacation, the city council has done that in the past, and occasionally it's been it's made sense. Occasionally it hadn't made sense. I think there were a number of vacations in the 1980s that I think came back to bite the city council. I know former councilmember Bain was adamantly opposed to any future vacations because having lived through that experience. That said, we do have instances in the city where there is encroachment. There's a street, for instance, called Valley View, which actually, nobody knows where Valley View is, but it actually is a platted street in the city that functionally is the backyard and the driveway of a property owner. But in that instance, there's no adjacent property owner that says, hey, I want access through this right-of-way. So it's never come before the administration before. I can come up with, we can look at the situation carefully and say the implications of a vacation would be this, and the implications of a reissuance of permits in another manner would be this, and bring that forward to the committee.
Thank you.
One thing I would note also, in the memo dated May 9th, 2022 from David Riggs, this memo was to provide City Council some additional information on the issue. Bullet point number 6 of his bullet points, alternatively, City Council may want to consider vacating the alley from the area south to the end of the alley, providing each property owner 5 feet of additional backyard space. And that is the document from our code director that helped form this recommendation that I brought forth today. He's actually put it in writing to council.
Yes, thank you. Okay, so first of all, do we have comments from members of the public who have not yet spoken that wish to speak now?
Councilmember Grace.
Yes. I apologize. Go ahead, Mr. Mayor. Sorry.
Let me just say that, another thing to kind of dovetail on what the director was saying is when we do this, there has to be guardrails because we have other alleys throughout the city. The alley between Morris and Ohio is an example, which has driveways or it has garage entrances in the back. So again, not opposed to the idea, but just making sure that we're going to have legislative guardrails on how these types of vacations of vacating an alley, how that process will work. I think in this situation, you're looking at the dead end, the furthest end south on that, I see possibilities there because I'm not aware of any garages that have access off of that alley that far.
I think there's one.
Is there one?
Yeah.
So yours?
North of
Not between that spot and the funeral home, though.
Not south of.
Not
Not
south.
south. That's what I was referring to. Anything further south, from where this.
Nobody's driven through there in 25 years.
Hughes Moakland has a structure blocking
I
it.
know.
It's impossible.
That I know.
And a raised parking lot.
Okay, so to return to some structure here, are there comments from the audience?
Hello, my name is Kurt Monald. My wife and I own the property that we're discussing in regards to gaining access at 70 South Shannon. Just for clarity, as you spoke, we do have property that adjoins, and we've used that adjoining property to the alleyway for access for maintenance purposes. A couple points I'd like to make. To my knowledge, there was no code prior to 1960, and I perceive the structure that was built, to nobody's fault of their own, was built prior to that. So we're dealing with a structure that really doesn't conform to any code that exists today. What I would ask the council to decide on is a fair and equitable decision for all the property owners that adjoin this alleyway, which includes us. And I would like everyone to think further beyond ourselves, and because all of these properties are going to convey to different property owners beyond what the current use and occupancy is. And the decision needs to be made that doesn't need to come before council again in the future. I fully support abandoning the alley from our property line, as Mr. Swink conveyed. I'm completely comfortable with that thought process in rescinding the access, and I understand the concerns, but I am not willing to concede that access without the abandonment of the alleyway coinciding. Thank you.
Thank you. Are there any other members of the audience who would like to speak? Yes.
My name is Beth Ferrier, and I have been contacted by the Myers regarding this. And my review of the documentation found a number of disturbing items, and those included that there was a memo dated February 9th referring to applicants, and at that point in time, Mr. Montal's special permit application had not been submitted nor received by the code office. So I don't know what that's about, but it raises issues in my mind. There are also, for council's reference, a good portion of the alley at the other end by Hughes Moquin had been vacated. And you'll find that in an ordinance, and I believe it's in 1982. I have a copy of that. So portions of this alleyway have been vacated long before, and it dead-ended. And there's a reference to some other various things. And I think there's some confusion about vacating and so forth. And I think the most disturbing thing about this whole situation is that all of the permits and references and ordinances spoke in terms of South Shannon, 70 South Shannon. But then when the permits were granted, both the Myers permit and the Montal LLC permit referenced 72 South Shannon. That was not part of the application process, the ordinance, anything. And so I believe the new structure is going to have a 72 South Shannon address, but all the permit, the ordinance, and everything refers to a 70 South Shannon, which they also own, and I believe they were going to access through 70 into 72. So then you start talking about things like private easements and other stuff. There are deeds involved in all of this that have references to different things. So I think we need to tread very, very carefully. And I'm going to leave it at that, but I intend to contact the law director to provide her with some additional information. Thank you.
Ms. Ferrier, did you provide your address?
Well,
Just
I have
for
an
our
office
records.
at 490 Richland Avenue, and
Okay.
I also live at 9945 New England Road, Stewart, Ohio. So I have nothing to do with the alleyway whatsoever.
Yeah, we just need it for our records. Thank you. Okay, are there any other comments from members of the committee, members of council, administration, or our audience? Okay, then that concludes that item on the agenda for this evening. And next, we move on to more property use discussions. And this next item on the agenda is what I think is very exciting. We're talking about next steps to move forward with some big projects here in the city. And the ability for these projects to happen is dependent on some collaborative leases between the city and Ohio University. So we will be talking about the location for our new fire station headquarters and some member prowl soccer fields and also some opportunities for development at the Ridges for Ohio University. So I'm going to ask Director Stone to provide us with some of the important details on this. And
Thank you, Member Grace. What I'm sharing with you is a document that's in your packet. You already got it?
Yeah,
All right,
thanks.
very good. But just a hard copy in case it didn't make it in there in time, because we just kind of finalized it here this morning. As I spoke to the council several weeks ago in an executive session about potential for leases.
Come for Debbie.
No, I have one.
You got one? Okay, got it.
Potential for leases associated with a variety or a couple different projects, and you know the mayor and I have basically been in negotiation with Ohio University to say what these leases would look like. in order for us to achieve our goals and for Ohio University to achieve their goals. And functionally, these would be simultaneous leases that would, leases, that would act together. The first section of the document that you have here are kind of what the goals are. And when I say lease, these are not leases for significant monetary value. These are leases for $1 or leases for $18.04, which is what we've done in the past with Ohio University. So really what we're talking about is use of property for the public good at both on behalf of the city and on behalf of the state of Ohio for Ohio University. So the goals identified in that first thing are, number one, to obtain control of the land necessary to build a new fire station, new headquarters. Number two, to provide additional recreation to the city for soccer facilities that are better than the existing soccer facilities we have off of the Hocking River and East State Street behind Walmart. And then finally, to ensure continued access to the Richland Avenue, Dairy Lane playground at the Southside Park, but at the same time allow Ohio University more flexibility as they look to redevelop the ridges. And then Ohio University's goals is to obtain an option to use that land at the Southside Park should they need it when it comes time to redevelop the ridges. And then number two, ensure the university students retain access to sufficient green space by Stimson Avenue. I know we've talked a lot about green space in that land north of Stimson Avenue as we've talked about the new fire station headquarters. And then finally, to retain space for a driving range. Ohio University wants to continue to have a driving range. They need to for NCAA sports. So there's a couple different facts here, and those are listed about the three different areas that we're talking about: Stimson Avenue, West State Street, and then Dairy Lane. And it mainly talks about the parcels and what the auditor's appraised value. The county auditor's site notes as the appraised value of the parcels that we're in discussing. So there's three exhibits. Exhibit A, Exhibit B, and Exhibit C that show really what this simultaneous lease arrangement would convey, access to both entities. And so for Stimson Avenue, the university would lease the entire 10.6 acres that they have there to the city of Athens, and it would be a 40-year term with the option to extend by 10 years, and that's purely the city's option to extend by 10 years, and then 3 subsequent 10 years terms for an extension of 10 years for each one with mutual agreement of both parties. And the reason that we picked 40 years is because that's the extent that Ohio University is permitted by state law to lease a parcel. It's 40 years, and then that 10-year option basically equals 50 years, which is the design life of the new fire station building. About 3 acres would be needed to build that new fire station. The remaining acreage would be maintained as green space by the city. Something to note that's not listed here in this particular document is, as we've been moving forward on the design for the power purchase agreement for the solar array, the land just north of this area was one of the areas that we had identified, and we subsequently, because of concern about access to this green space and a couple other reasons, have basically removed that from the power purchase agreement, and so that would also remain as green space, and that's the space that's just between the river and the library also. So it's a significant amount of land that would be retained and maintained as green space by the city. The university did note that they would reserve a right to, if at some time in the future wanted to expand on the public safety building that the city has built there with the fire station and build like an annex to it for an Ohio University police station. They want to have the authority to do that. However, there are no plans at this time to do that. And then lastly, should they do that, they would want to retain a right-of-way along the northern portion. And that's noted on that exhibit there, or I don't know if the right-of-way is noted, but basically they would retain access. They need to be able to retain access from Stimson Avenue. For Dairy Lane, the city would lease the 17.8 acres to university, and ultimately we would lease it to them, but it really is leasing an option to use because until such time that the university would decide to utilize that space, we will continue, the city will continue to maintain and operate Dairy Lane Park the way that we currently have and the way that we've done for a number of years. In the middle of the Dairy Lane Park, there's 2.2 acres that encompasses the playground, the shelter house, the bathroom, and the parking lot, and that would remain under the control of the city. And then if there ever was to be a need for Ohio University to use that, the city council would have to approve at that time modifications to that facility. And we knew, as we talked about that was, kind of a sacred facility, and that there have been so many community organizations that have volunteered and raised funds to improve that particular playground. So if there were going to be any changes to that, we would want a future city council to have the authority to decide that, as opposed to it, being left in the hands of the administration or to Ohio University without city council's input. And then, like I noted, the city would continue to maintain and operate all of that area as Southside Park until such time that Ohio University would utilize it. And again, there are no plans at this point, at least that's what's been conveyed to the mayor and I from Ohio University, to do any development at the Southside Park. However, as many of you know, the Ridges Advisory Committee has been working with Buckeye Hills, looking at what a redevelopment would look like at the Ridges and how it could be done utilizing a new community authority. And I think before too awfully long, a couple representatives working on that on behalf of Ohio University are intending to approach City Council and present about what a new community authority would look like that would allow for redevelopment of the Ridges. And then lastly, on West State Street. And West State Street, and this would be for a shorter term, not the 50-year term that we're talking about, because I think that it's probably closer to about a 20-year term, which would be in line with what we've done with a lease for the land behind the community center. But basically, the city would lease land to the east of the current driving ranges and then improve that land. I have it on the right document. Yep. Improve that land to be able to place soccer fields in that area. We have an access agreement right now, which is just an administrative access agreement, a right of entry, that has allowed for soccer use here for the spring. That will continue here into the fall, and then our goal is to improve some of that space with better drainage, better grass, so that the full land could be utilized, and then ultimately buy a fence or buy a large net that would prohibit golf balls from slicing onto the soccer fields, and then we would install that once we get under a long-term lease with Ohio University. So those are the terms that the mayor and I have negotiated with Ohio University, and in future council meetings, we would be bringing forward the actual instruments to execute, both to grant the lease to Ohio University on the Southside Park, and then also receive the lease from Ohio University and enter into the lease on the other two properties. Sir, did I capture it all?
Captured it all.
Okay.
Thank you, Director Stone. That was very thorough, and I appreciate the university and administration sort of taking a comprehensive look at some of our different property needs on both sides to find some ways that we can collaborate and make some of these projects happen. Are there any members of the committee that have questions? Member Krell and then Member Spiel on this.
Thank you, Member Grace. I also appreciate the city administration and Ohio University getting together to find a way to work together on this. However, there are a few details in this agreement that aren't ideal. And that is that if we are really going to make a soccer facility in this location, we really need to think, as somebody who's been down there with measuring tapes for the past couple of weeks, trying to figure out how this space works as a soccer complex, we need to take in the size of those fields when we look at this space very specifically. Whether it's the bad area we talked about, whether it's the fenced radio tower, there are places there that you can't put soccer fields because of infrastructure, and I think some of that is reflected here in this blue shape. However, one of the things, it was great, the meeting we had down on the fields with the upper administration of Ohio University and the city administration to talk through this, and I thought everybody was open to making this work, and I really appreciated that. I'm not sure exactly why in the mutual agreement it does say under West State Street, under Part 3, in the short term, in August, the city will be permitted to move one field to the intramural fields for fall to allow grading and grassing to occur in September. There are 2 fields necessary for the adult soccer community. It is logistically possible to have 1 field on one side of the city or in 1 field on the other. It's not ideal because a lot of players play on different teams and pick up, et cetera. But more importantly, I'm concerned about what the plans are for this West State Street area because there's lots of repairing that needs to be done. So there's not going to be space for a full field there if we have to have 1 field there and 1 field over on the intramural fields. Now, I thought some of the OU administrators were open to us using that space. Clearly they are for 1 field. I can't imagine that 2 fields would be a huge problem or an ask. So that's one thing that I would hope that we could, I appreciate, because we also heard from the OU officials that perhaps the space at the West 8th Street could be slightly wider, and I do note that you've written that here in the long-term agreement, that it's possible that the area could be widened by 15 to 20 feet. I think that's wonderful. I would just say that either our GIS people or people join me down there with measuring tapes to figure out what really works in terms of the space, instead of just saying, hey, let's ballpark this much and let's hope it fits. Let's figure it out so that it really does work. But I also, the language about the South Side Playground, I really appreciated seeing that it would take further approval from City Council to ever use that for anything. That was really important to me, and I know other members of council too. So thank you for that. Thank you, members.
Thank you. And Member Spielness?
Well, this is sort of a basic question. Thank you.
Did you want to speak now to
I
something?
would, and Councilmember Prowl, you looked at the diagram where it does have the dashed blue line.
Yeah.
Okay, just wanted to make sure that, that would be the official use of that when that time comes.
Right. Can I just follow up real quick? So there's a manhole cover in there.
Yeah.
Right, so that's one of the problems with knowing exactly where we can put, because that manhole is not going anywhere, I don't believe. It's a raised manhole, right? It's a good, 1.5 feet off the ground. Now, I don't know, maybe Director Stone can say I can put that down. Okay. All I know is it's hard to play soccer with that manhole cover sticking up 1.5 feet on the field. So because at one point with the mayor, we were talking about getting 3 fields into the space. But we know also the electric lines are coming across. I believe this blue extends north of those electric lines, but the agreement says that the property north of the electric lines will be left for Ohio Student Farm expansion. So we're going to have to figure out if we're stopping at the electric lines, that's different measurements than being able to expand. We have the cricket pitch we've talked about, that's no one knows, So there's some things still, I think.
And I'm sorry, I would agree. There needs to be a level of clarity. One of the things that I've directed the Arts Parks and Rec Director to do is hire a design firm to do an actual boundary survey that is, because we're gonna have to do that for the lease anyway, that has the meets and bounds of the area particular. And when they do that, to do a topo survey and then really lay out how the number of soccer fields would fit in the space, where the net would go,
Right.
And then identify those obstructions and what improvements would be made to mitigate those obstructions, as well as the grading plan to bring up the goose poop area that we talked about out there. I'm sorry, at the meeting, we talked about an area that goose frequent in this particular spot because it's low and lays in water, and so that's gonna have to be brought up and graded, which is what will happen in the fall, as the soccer activity moves over to the intramural fields.
I just say that we have other members of the soccer community here and who know that we've been calling Walmart fields the goose poop fields for
I'm gonna confuse it, aren't I?
and we're trying to get away from, but it's okay.
All right.
Sorry, members. I'm sorry, Member Grace.
No, go ahead, Member Spielness.
Okay, those are fun things to talk about in many respects. I'd like to talk about something much more fundamental, and maybe this is my inexperience in this sort of negotiation, but I can understand how many of these things could be leased and, have those discussions, but I'm just curious, and perhaps other people might be interested too, why there isn't, or what the reason is that we don't have purchasing or trading of land or something like that to take care of it. I guess I'm particularly concerned about once you build a fire station, once the lease is up, that building should be there for a lot longer. Is there any risk there? I don't know, maybe I'm the only one who thinks of that, but I think I might not be the only one, so an answer to that might be helpful. And the other thing that I brought up before is that part of the reason people were concerned about that location for the fire station is the fact that it's so big and heavy, and it's on a floodplain. So the extent to which there's the geotechnical analyses, whatever, have been, and the engineering has been done to really fully determine what has to be done to make sure that we are not going to have a collapsing fire station as we do now. Understandably, there are different reasons for that, but still, I think it's a legitimate question, and perhaps I'm a little jaded after the University Estates bike path situation, that we are really careful about this.
So I would just, the city and the university have other long-term lease agreements, and so historically, there haven't been conflicts. For instance, a corner of the parking garage is on university property. I think the corner with the elevators, right? So a portion of the city parking garage is on the university property, and so we, as a city, in a university town or university in a city, frequently navigate these sort of use agreements and collaboration, and also the 50 years is the anticipated life of the building, as stated by Director Stone, and so we are certain we would have right to the property for the anticipated life of a building, but I will defer to Director Stone for any other, or the mayor for other comments on that.
I'll give one more example of a lease agreement that we have with the Athens County EMS station, the new station at the end of Kenny Drive on the 13 acres of land that we acquired from TS Tech to use as a safety training center, safety services. That building is on a 35-year, I believe, 30 or 35-year land use agreement with the county. So it's not unusual to do have agreements, lease agreement arrangements like that.
And I'll take your questions in parts. The first about the length of term for the lease. All of the development on East State Street is on Ohio University land, east of the community center, out to Lowe's is on land owned by Ohio University and in a long-term lease agreement with a developer that subsequently leases it to businesses to establish retail establishments at the location. So it's pretty common for Ohio University to lease land versus dispose of it. I think that the state of Ohio laws related to disposal of state property is a pretty high bar versus the laws associated with leasing state property. It's still a high bar. I mean, it still requires approval by the Board of Trustees to grant it, and the Department of Administrative Services to oversee the lease. In many cases, rather than dispose of property, they'll just lease it for a long term. And if someone is borrowing against it, there's a certain point, and I won't speak like a banker would because they would know definitively, but as far as they're concerned from mortgages and such, once something is in so long of a lease, it functionally counts as like ownership for purposes of lending. So our thought with this term was it was appropriate given the design life of the building, and that at such time, if it's still functional and working in the future, those options could be exercised and extended. With regards to the geotechnical questions that you had, I would draw a contrast between a slope stability situation and a flat bearing capacity situation, and that slope stability is more difficult to predict. Just the behavior underneath the ground, and I know that you've met and talked extensively with both the city engineer and assistant city engineer about the situations related to the University Estates bike path spur and the slip or slips in that particular area. So we won't belabor that, but in this particular site, the design firm is number one. In addition to geotechnical borings, where they'll look at bearing capacity of the soil to ensure it can support the slab necessary for this foundation, as well as the live load that will be inside, as to say the trucks. They'll do that. Number two, the fill necessary to get above not only the 100-year floodplain, but the 500-year floodplain, which is necessary for an emergency services building, will ensure that we meet that elevation as well, and that fill is placed correctly, so that you don't have a subsided situation. The current fire station, again, is unique because you have 80,000 pound, 90,000 pound, 100,000 pound apparatuses on the second story of a building, whereas with the new fire station, they'll be on the first story, slab on grade.
Are there any other questions?
Thank you.
From the committee? Yes, Member Crowell.
Oh, thank you. And just to address another, something that I've heard in Ward 3, and I'll let Director Stone respond to this too, which is also about flooding and some of these issues that our constituents are concerned about. The concerns that I've heard have not so much with the building itself, but with building up the property and then the displacement of water, perhaps going into homes on the Near East Side. Do you want to address the potential of that occurring?
Flood behavior is complex, and this is not a lake where if you had a lake and you were filling in one spot in the lake, it would displace the water in another spot to push it out. It's not like a glass of water. River flood behavior has a variety of variables associated with it. Mainly because of the drainage areas that supply the water for the flooding, constrictions along the length of the river, and then the slope and the nature of the channel. So to say that because you're filling here, it's going to immediately make the water go and move over to there is just not true when it comes to flood behavior. We have flood damage prevention regulations in our code that allows for development in the floodplain. The floodplain is distinct from the floodway, which is a portion of the floodplain that is in the center of the river. And when you build in a floodway, our regulations require you to demonstrate that you aren't displacing water upstream of the structure that you're building or the fill that you're placing, and they have to do. Anyone who would do that would have to provide a significant amount of engineering analysis through computer programs that would spit out a product to say that they're not causing a rise above that development. In this particular instance, it's in the floodplain. A significant portion of Athens is in the floodplain, and every day we look at developments that occur in the floodplain and permit it. In those instances, the law requires that people build the finished floor of the first finished floor 1 foot above the 100-year floodplain. So at such times that we have a significant flood event, FEMA, which is the entity that provides the federal flood insurance program, is not insuring something or not paying funding for something that a community had the ability to go and regulate to have be out. So I do not anticipate and do not believe that building this is going to cause any more flooding anywhere else in the city of Athens than we currently experience.
Thank you. Are there questions from other members of council? Yes, Member Swank.
On Exhibit A, currently both the blue and the green are owned by and maintained by Ohio University. Obviously, the blue will be ours, so to speak, and maintained by us. Who will maintain the green area?
Under the terms that we've negotiated, the city will maintain that as well.
Okay.
So to the point of maintaining it as a green space, the city would then have control to do that.
Okay. So then when we move to Exhibit B, several questions. At the current time, Ohio University owns and maintains all of that, green and blue. When we take over the blue, the soccer area, I assume we will maintain that.
Correct.
So what we've added here is additional space that the city of Athens will be responsible for maintaining. do you foresee being able to minimize the amount of attention that we pay to the current soccer area out on East State Street by Walmart to perhaps offset the workload for this?
I do. I think that we don't want to let that go back to nature.
True.
But I think that once those are deprogrammed or lesser programmed, the fields there by Walmart specifically, we can mow them less frequently. And then that frees up capacity to be able to care for the land on the West State Street Park that we're expanding and adding more. And really, we're really talking about mowing, and that's and there's other maintenance as well that we have to do. But mowing is the big demand, particularly during the season that they're being used. With regard to the land off of Stimson Avenue, my idea at the moment is to have our firefighters mow that. They have a good, as opposed to our Arts, Parks, and Recreation crew, which currently maintains the land north off the picture here by the library. And I think I can do that because it's adjacent to the facility. They get a good high-speed mower. They can do it not unlike what they do right now with caring for the lawns at the existing 2 fire stations. And then if they get a call, get off the mower, leave it, go get on the truck and go.
So with the West State Street soccer facility, now that we'll have a dedicated soccer facility that's not flooded and having trees and everything else float on, do you think we're going to be able to maintain grass height there to make it actually playable?
I'd like to think that we can. The current southeast corner lays in water when it's very rainy, and it ends up. That's an area we're going to have to do some grading and planting, and possibly even some sod, depending upon how quickly we're attempting to reutilize it. But it's better. It's in better shape than the just by the fact that it doesn't flood very frequently. The rest of it than compared to the West State Street. I'm sorry, the East State Street.
East State Street. Yeah. Okay, great. Thank you.
Council, other questions? Are there questions or comments from members of the audience? Okay. That concludes planning and development for this evening.
Thank you, Councilmember Grace. We'll now move on to Finance and Personnel Committee. This is chaired by Councilmember Crowell, joined by Councilmembers Reisner, Ziff, and Spielness.
Thank you, President Isley. 2 items on Finance and Personnel tonight. The first, accepting amounts and rates as determined by the Budget Commission and authorize the necessary tax levies. This is a resolution that we do annually to accept the amounts and rates from the county auditor for the city to receive the inside millage for property taxes in Athens Township and Canaan Township. That is 2.6 mils in Athens Township and 2.4 mils in Canaan Township. The resolution that will come before this body authorizes these tax levies and then certifies them for the county auditor. The county auditor has requested this by October 1. This would be a 3-reading resolution. It would go into effect January 1st, 2023. Are there any questions about this item on our agenda from the committee? Other members of council? Members of the audience, city administration, thank you. Next item on our agenda, Capital Recovery Services Agreement and Specialty Docket Grants from the Municipal Court. This is an agreement that with a Columbus-based firm for 1 year that would allow the Municipal Court is requesting to enter into this agreement with Capital Recovery Services in order to collect outstanding fines and fees, if I understand correctly from the agreement by Ohio State statute. A 30% collection fee could be added to these fees, and that is the amount that then the Capital Recovery Services would receive for collecting these on behalf of the city. But we have the Clerk of Court with us tonight. If you'd like to tell us more, we'd appreciate it.
Hello, I'm Tanya Dye, Clerk of Court. I was requesting this as another alternative for our collection efforts. Currently, we do go through the Attorney General's office. Speaking to a lot of other court clerks, they actually use both a private collection and the AGO. So this would give us another alternative to use to collect outstanding debts. this company in particular is used by several courts throughout the state to great success. So that was one of the reasons to, like I said, try to enter into this agreement.
Just because we've talked about fines and fees with Judge Grace recently,
Exactly,
does that sort of plan
yes,
come into
part of
play
it
here?
does, yeah. We are still very much looking at our fee structure. We do look at who we do send to collections. That is a major project, actually, especially for me, looking at, especially for indigent offenders. There is a limit, that we do set that's like, okay, we're not going to see, some of these are collectible. We also know, so we are certainly looking at this. Part of the major problem is where we do accept partial payments. Sometimes that goes below the limit that we can send currently to the Attorney General's office. So it could just be that, you've made one payment, you've forgotten about it, you've moved on and graduated, and we're sort of at an impasse on what we can do. I know though, just spoken with the Attorney General's office and gotten our structure lowered, but like I said, courts across the state have found that utilizing both has been to their benefit.
I did note that the agreement doesn't give the Capital Recovery Services a blanket permission to go after any delinquent fees. The courts specifically say, here is a claim that please help us with.
Yes, yes, and I review those, and like I said, there are some that we have flagged and went, this isn't collectible. That is one of my projects as well, is to review those, especially for people who are currently incarcerated, which you're not allowed to send to collections, but to see about just eventually trying to waive those costs and remove them from the books. We've got some people who are going to be incarcerated for 30 years. They are not going to remember that they have fines and fees owed to municipal court by the time they are released from the prison system. So, and it would be more burdensome for them to try to restart, finding they've got some of these just small amounts outstanding.
Sure. We sort of have two items on this agenda, and we'll get to the second one here in first, but does anybody from the committee have any questions about this capital services agreement? Yes, Member Spianis.
Thank you. Thank you. Just a couple quick questions. You said that the Capital Recovery Services has great success. So I'm wondering if you could quantify that percentage of, recovered tax money, that sort of thing. I think that would be helpful to get a sense of. And then I can follow up.
Exactly. Whereas right now, the majority of the success for the Attorney General's office comes around tax time, because they can reclaim tax refunds, essentially. One of the things capital recovery can do is, go after that really all year, and try to focus on collecting that through, telephone calls, all the standard collection practices. I don't have currently, what the success rate. I have not looked specifically at that for tonight's meeting, but I can get the information to you regarding some of their other collections across the state.
And a quick follow-up.
Please.
To that too. Also, I noticed that it was 30% was their take on this. So how does that compare? I mean, of course they need to get paid something, but how does that compare to other options? I mean, is 30% a standard rate?
It's a standard rate among collection companies. Okay. The Attorney General does have a lower rate. The other avenue we can also go is with potential registration blocks on people's vehicles, but there's concerns also on that. It is an option, and a lot of courts do use that as well. So amongst the three, that's usually what a lot of courts use across the state, or a collection of the various three options.
Okay, thank you.
Other questions from the committee? Other members of council? Yes, Member Swank.
I'm curious, how much money do you think we're owed at this point in time, ballpark figure?
I know we have sent probably at least 800,000 already to the AGO. It's
Sizable amount of money.
It's sizable amount.
Okay, great, thank you.
Any questions? Yes, Mr. Mayor.
Just as a reminder to city council with the previous question, again, asking about the 30%. With CCA, Cleveland Collection Agency, that's 25%. So it is high, but, you know, for the return on investment.
7% of something is better than 100%.
Well, if I understand correctly from the agreement, and maybe Member Spelness saw this too, is that 30% is added.
Correct.
So you're actually, the city is receiving all of the fines and fees that they're getting. There's the Ohio Revised Code allows us to add 30% to a collection agency, which is what they get, and we still get the full 100.
Correct.
So I don't know, the CCA may be different, but in this case, you're not losing it.
And that's the same way actually the Attorney General's office works as well.
Is that right?
Is they add their fee, we get our full requested amount. We could also renegotiate and ask, for interest and other things with the Attorney General, which we do not. But yes, they collect a fee as well, which is in addition to what our costs are.
Okay, great. Any other comments on this issue? Okay, there's a second item on this agenda, which is specialty docket grants, and I'm not familiar with what this agenda item is, so please help us out quick.
Last year, through the Ohio Mental Health Board, the SAMI, Substance Abuse Mental Health Docket, and the DUI Court were both granted 2-year grants. That second year begins in July, when you will all be on break, on hiatus. So I wanted to make sure that we could allocate those funds. They have been in the budget. Based off of my numbers, I did include that use for when those checks did come in. However, we might need to adjust some line items, between supply and salary lines. So I just wanted to make sure that we could utilize those funds as quickly as we could, versus trying to do first and second readings in August.
Understandable.
Because we do have a deadline of July to use those funds. The SAMI court grant is $25,000. The DUI court grant is $35,000. So.
Okay, well, thank you for bringing that information tonight. Any questions from the committee? Ms. Dye, other members of council, city administration? Thank you so much for the long wait tonight. We appreciate you being here.
Not a problem.
President Isley, that ends Finance and Personnel.
Thank you very much, Councilmember Crowell. We'll move on to City and Safety Services, chaired by Councilmember, I'm sorry, I've got the wrong thing, I know. It's you. It's Councilmember McCary, and joined by Councilmembers Grace, Swank, and Crowell.
Thank you, President Isley and committee members. We'll go ahead and get started with our City and Safety Services Committee meeting. We just have 2 items on the agenda tonight, and the first is a salt pit roof rehabilitation project. I have some notes here. Project number is still pending, but this project will remove and replace the roof slab and beams for the water treatment plant salt storage areas. The project was noted in the 2015 needs assessment for the water treatment plant. And I don't know if Director Stone has anything that would like to be added, other than the cost estimate being $215,000 at minimum.
Right, so what these are, this is part of the original construction of the plant. You know, when you soften the water, you put water softening salt down on the ground, you create brine that you use to recharge the zeolites and the softeners. The way that those are loaded is big tractor trailers come in and they pull over top and then they dump down into these pits. The roof of these pits that the tractor trailers drive on over the years has just degraded and really needs to be replaced. The cost, we're looking at $215,000 estimate for construction. We already paid $20,000 in engineering, but because this is going to be a project, we're going to have to capture that in the authorization. And then I'd also like to ask for an additional $20,000 for contingency, depending on how bids come in and such. So what I'm asking for is an authorization of $255,000 and an appropriation of $235,000 to pay for this project.
Thank you, and it does sound like this has been an anticipated need for some time that we've been prepared for.
It is. I've put it off a long time. I mean, I've looked at these all the way back to 2000 and before I was in charge of engineering and public works, when I was just in charge of streets, I went and did an assessment, and we've put this off as long as we probably should. You know, there's no reason in some of those earlier years to do it, I thought, based on the condition of it, but it's getting to the point that the condition is such that we need to go ahead and do it.
And at this point, does it cause any safety issues or concerns?
If we didn't do it in the next couple of years, I would say, yeah, it would. It's time. It's time.
Thank you.
It's not catastrophic safety issues, but it's stuff that, you know, you could have when you have a live load on there, you could have a situation where you had not necessarily, it wouldn't be a catastrophic collapse, but it could be like that with a truck on it, which wouldn't be good.
Okay, thank you. I'll open it up to questions from committee members. Councilmember Swank?
Are these the pits down on West State Street? If you're standing at West State Street and you move toward the back, and they're all rusted out, and because Sully took us down and gave us a tour.
Probably, they're behind the water treatment plant.
Yeah, they're in really bad shape, yeah. Okay, great.
They're 40 inches thick of concrete with 2 layers of rebar, so, and they do look pretty bad, particularly when you're looking down underneath it, but, you know, there's still some life in there. That's why I don't think it's, you know, an imminent collapse tomorrow, but this is a project we need to get done.
Get ahead of, yeah.
Thank you. Other committee members? Questions or comments from administration? Other council members and audience? We'll go ahead and move on to the next agenda item, and this is Recreation Advisory Board. This is a topic that has come up in the context of just clarifying the charges and responsibilities of our various boards and commissions. I know that as chair, I've had some communication with our mayor, our Arts, Parks, and Recreation director, and even some commentary from our auditor, just acknowledging that there has been some confusion in terms of responsibilities for the what is currently titled the Parks and Recreation Advisory Board, but has been operating for at least some time with the assumption of responsibility for arts as well. So I wanted to take this as an opportunity, although I've had one-on-one conversations, to publicly clarify and invite questions or comments about the setup of our commissions and boards that are intended to support arts, parks, and recreation broadly. And I can also share that one of our Arts, Parks, and Recreation Advisory Board council representatives is here with us, and I believe that Councilmember Swank can add some comments to this conversation as a member of the committee.
Yes, sir. Interesting, Thursday night we had the third Thursday of the month Arts, Parks, and Recreation Advisory Board meeting. And at the 38-minute mark of the film, you can watch this topic came up. And it was very interesting. 3 of the holdover members actually articulated that they probably wouldn't be on the board if it weren't for the arts component. In fact, one gentleman who's about to leave the board mentioned the fact that that was the Parks and Recreation are important, but the arts component is what made him say yes to the nomination. And I just called up on the website here. We just recently redid our logo, and it actually says Arts, Parks, and Recreation on it. So kind of what we were looking for, what the committee was looking for, the advisory committee, was, a clear statement. What makes this unique is that within the Arts, Parks, and Recreation Department, we have a dedicated arts building, Arts West, that has programming many times 7 days a week. Everything from bringing kids from the current West Elementary in after school to, Chelsea's here, she can go on and on and on and tell us all the things. So we have within this department an actual dedicated arts building. So it's a huge component. In fact, last year when I was chair of the committee, we changed our agenda so that every meeting we had an arts component, a parks component, and a recreation component. And then there was an ordinance last year that kind of, I won't say dropped it, but didn't have arts in there. So there was concern that yes, we are a true Arts, Parks, and Recreation committee, advisory committee. We also have AMAC, and the two of those hopefully working together can promote arts in all aspects of life in Athens, just not in the arts community.
Thank you, Councilmember Swink, and I'll go ahead and send it to Councilmember Crowell.
Thank you, Member McCary. So I'm just a little bit confused here. Looking at city code for the Recreation Advisory Board, it's called the Recreation Advisory Board, and it's also called, I believe, the Recreation Program Advisory. The program's in there at one point, but it doesn't refer to the arts. So is this agenda item to simply change the title or to change the mission of because the Recreation Advisory Board talks about recreation. When I was on the Recreation Advisory Board, we didn't talk about arts, but that was a different time. I'm not against either one. I would like to hear from the Municipal Arts Commission, and maybe Member Reisner has something to say there. Should recreation be part of their charge too? I mean, if we're taking arts and putting it on the Recreation Advisory Board, would we take recreation and also put it on the Municipal Arts Commission? I'm trying to understand. It seems to me that we have separate things for separate reasons. So I'm a little bit confused as to, and for those members who are on the board and came because of arts, I understand that. And maybe they don't want to be. I think there's lots of people in the community who are interested in recreation. Certainly our pickleball community is very active, and I know our soccer community is very active. I don't think we'd have a hard time finding people who are really interested in recreation. Not that I want to lose anybody who's very interested in arts, but maybe they'd be a good candidate for the Municipal Arts Commission. I'm just trying to understand exactly what this agenda item is. Is it just a name change, or are we looking to redefine what the Recreation Advisory Board does? Thank you, Member McCary.
Thank you for those questions. I would say that this has been a point of confusion, so I appreciate those clarifying questions. And the idea would ultimately, from my perspective, be to have the names of commissions match the implied responsibilities. And I would say that part of the confusion from my perspective since joining council has been that we have, from an administrative perspective, arts, parks, and recreation lumped together, but that was not the intended structure for our Municipal Arts Commission, and that from my understanding, we are hoping to maintain a level of attention on each component, arts, with a dedicated commission, as well as recreation, and I think at this point might need to turn things over to the administration for some comment and clarification.
Mike, real quick before you go. Well, a good starting point of the conversation would be to simply go to the Athens Arts, Parks, and Recreation website. And at the top, there are 3 tabs, Arts, and the things under Arts are Arts West, Programming, Special Events, Gallery Shows, SEO Musical Lending Library, and things under that. Then there's a tab for Parks. And under that, I won't read all these, you can look at it themselves, but it lists all that, and Recreation, it lists all that. So I guess if there's any confusion, that's maybe where it comes from. We display this, but how do we practice it, and how do we integrate it with AMAC?
I appreciate those comments, and I think there may be some discrepancies in what we have written as far as responsibilities and charges of the groups versus what they're called, and then even what they've been putting on their agendas at different times under different leadership. So I'll go ahead and pause and turn to the mayor for any comments.
Thank you, Member McCary. Let me just read the duties, powers and duties, the pertinent powers and duties of the Rec Advisory Board. Advise the administration on matters related to the adoption of programming, policies, and procedures for operations, equipment, and maintenance of parks, playgrounds, play fields, public baths, which I don't know that we have any public baths, swimming pools, indoor recreation centers, gymnasiums for land or buildings, owned by the City of Athens, not dedicated to public use other than for recreational uses. That is probably the number one item to share. There's three other bullets. And then you look at the powers and duties of AMAC, and I'm not going to read through all these because it's very lengthy, and I should give a shout out that AMAC is 20 years old, so congratulations, AMAC. The powers and duties of the Municipal Arts Commission may be, but are not restricted to the following: the study of current status of arts in Athens, to establish policies for juried selections of art presentations and installations, to develop policies and procedures for public art and the maintenance of same, in cooperation with the Parks and Recreation Department, recommend to the proper authority the addition of arts in Athens with particular attention to parks, bus stops, gateways, open spaces, municipal properties and buildings, and then next bullet, in cooperation with Parks and Recreation, recommend city performance venues and encourage the development of performance programs. And there's 7 or 8 other bullets on here. Both of these boards are advisory to the mayor. I make the appointments to those. In 2017 or 18, I did make an appointment of an individual who is an artist, and it was to establish at least a liaison and get communications flowing between the two departments, or 2 different boards, which I don't know if originally in 2002 that there was a lot of communications going forward between the two, but I can tell you now that in all my time serving on AMAC as a council representative and then attending AMAC meetings, and now it's with Councilmember Reisner as the council representative, there isn't a whole lot of communications back and forth between the 2 different boards and commissions. I would like to see them engage with each other at least, semi-annual. I'd like to see them do it quarterly, quite honestly, to where they come together and talk about what arts programming they would like to see in the parks. This summer, for the first time ever, in the city park spaces, we have the music in the parks. I'm hopeful that it can expand in the future. But again, to have that coordinated effort, there should be communication with the Rec Advisory Board. I would contend if you're going to amend anything, change it to where it's the Parks and Rec Advisory Board, because when you look at the mission of that, it's very different than what the mission is for our Municipal Arts Commission.
If I could ask you to just add to that, any comments about the shared leadership and budget over all 3 areas?
Well, sure. From an operational standpoint, it's through the Director of Arts, Parks, and Recreation. And, annually, when we put together the budget, there can be budgeting for certainly we're doing it for AMAC this year, and we'll continue to do so with the Athens Arts and Music Festival. And, but really, when you think about it, from the Parks and Recreation standpoint, that's all budgeted through 270, 272, 271. It's coming through the revenue that gets generated by the levy, and as well the programming that currently takes place within Arts, Parks, and Recreation.
Thank you. Other comments from committee members?
So just for clarity's sake, if I may, Member McCary, we have one city department that is Arts, Parks, and Recreation, and we have two boards that serve to advise that city department.
No.
One that is focused on arts, AMAC, and one that is focused on the recreation and parks. Although art in the park certainly brings those together. So to me, that is clear and makes sense. Like, yeah.
Yeah, so AMAC, basically the way this is set up, is advisory to me, not necessarily advisory to Director Catherine Ann Jordan. Although, where the director gets, in the loop on these things is from an operational standpoint, because that's her job, is to make sure that maintenance and operations are going, and that includes Arts West. But the art programming that takes place in just the programming period is through Emily Beveridge, who also works and is on the AMAC board and kind of has a permanent seat because of the showcasing of art inside Arts West, the performances that go on inside Arts West. It's this, and it's when, and I might lean on the clerk of council just a little bit, but when we acquired the Nazarene Church to become Arts West, it could be very likely that about that point in time is when the arts component all of a sudden had to land somewhere within the city administration, functionally. And so Arts, Parks, and Rec picked up the art to include that with what's going on within Arts West. So again, that's 2002, maybe in late 90s. Clerk of Council, do you know by chance?
And we needed a historian too. Wasn't there a Quonset over on the community center grounds that was more for the arts too? And that building was taken down. And around that time, I seem to remember a conversation with City Council member Carol Patterson, who was the strong advocate for the purchase of the church.
If I could ask the mayor to just clarify one point you made just a moment ago in reviewing the charge of the Rec Advisory Board. Specifically, there is mention of parks being included in that, and we've also heard from Councilmember Grace that there could be some overlap between arts and parks. But I heard you mention a moment ago, if you had a suggestion, it might be to add or update the title of the advisory board to Parks and Recreation Advisory Board. Is that a solution that you see as helpful here?
The Rec Advisory Board advises on, the parks themselves and what's going on within the park spaces.
Okay.
I don't have issue with that name change, but what I don't want is everyone to really become thoroughly confused by calling it the Arts, Parks, and Recreation Advisory Board,
Right.
because we do have the Athens Municipal Arts Commission.
Thank you. Other members of council? Yes, Councilmember Reisner.
I just want to throw in my 2 cents. I really don't see any need to change titles here. I think the way the system's set up, it works. But the mayor does have a good point. We're not communicating very well. And I like the suggestion that the two boards and the mayor should come together semi-annually or quarterly, exchange views and ideas and programs, and in other words, communicate better than what we are right now. AMAC meets and then they meet and they do their thing, everybody does their thing. Not a whole lot of together things.
Thank you. So I'm hearing some communication improvement opportunities, perhaps not only between boards and commissions, but also perhaps with what we put out publicly to explain what these boards are focused on. Councilmember Spielness?
Well, I guess it's kind of, to me, a little bit confusing, certainly, and perhaps operationally confusing. If there's an agenda item for arts in Arts, Parks, and Recreation on a regular basis, but the Arts Commission does art stuff, so it seems like they could be at cross purposes or maybe even duplicate, efforts if they're not communicating and if both of them are doing arts. So I would think that there would be some advantage to changing the name simply to clarify the mission. But, you know, I'm not familiar, I'm not an expert on any of these things. It just, from listening to this, it sounds confusing.
Thank you. Councilman Procol?
If I may respond to the members beyond this. Currently, the name is the Recreation Advisory Board and the Municipal Arts Commission. So there's no confusion, I don't think, there. I think the confusion comes in if you call it the Arts, Parks, and Recreation Advisory Board and Municipal Arts Commission. But in our city code, it's called the Recreation Advisory Board, RAB.
Can I respond, though?
Yes,
Except
please.
that Member Swank said that functionally, they do have agenda items for arts, parks, and recreation when they meet as the recreation board. So it's being, I think, people see it as arts, parks, and recreation, even though technically that's not really the name. So
I guess it just depends on who's seeing it. I mean, I
Yeah.
never saw it as the Arts, Parks, and Recreation Board. I saw it as the Recreation Advisory Board.
Well, I would say if they're doing art, they shouldn't be.
I
Well,
appreciate
that's my
all
point.
those comments and recognize that, yeah, there clearly are some opportunities to provide clarification, even if it's only in establishing whether or not this Recreation Advisory Board should continue to have arts items on the agenda. Questions from other council members before we go to the audience?
So what is the department called?
Arts,
Parks and Recreation.
Okay. So that, I guess therein lies the confusion. Because we have the umbrella for the department.
Yeah.
And under that umbrella, we have two people standing, trying to stay out of the rain. Two different committees. Because I'm looking at this website, and a layperson, not being privy to this conversation, would say that we have an Arts, Parks, and Recreation Department, and they do it all. So I guess my question is, as the liaison to this committee, what is the message that I need to take back to the folks on the third Thursday of next month? Because, again, 3 people, one of them brand new, signed up for this because of the arts component to it. To be on the advisory board.
I would go back to saying that there needs to be a quarterly meeting between these two boards so that if there are arts-related items that are on the Rec Advisory Board's agenda, without AMAC knowing what arts things are on that agenda, you know, that's not part of Rec Advisory Board's charge as an advisory board. That's in the art world. Both can coexist underneath the total umbrella of arts, parks, and recreation, and both need to. But again, I would say that one of the things I would bring back is that there should be a meeting once a quarter that is with both entities coming together and informing each other.
Okay, I think we have time for just one more comment from council, then we'll move to the audience. Councilmember Smilas.
Yeah, it seems, yes, I agree with you, Mayor, that seems great. But it seems as though some things might come up that why not copy them if it's an arts thing, or say, hey, we've got an arts thing that's come up, you know, here, you come to this meeting or we'll copy you on it. I mean, this isn't hard. It just, I don't know. But yeah, communication's super important. That doesn't need to be said again. But
Thank you. We'll switch to the audience. And if you could come to the podium and share your name, address, and whether or not you represent any organizations.
I'm Rob Delac. I live on Morris Avenue here in the city and just representing myself for this discussion. So I've attended 15 to 20 meetings of the Recreation Advisory Board in 2017, 2018, back when I was attempting in an unofficial capacity to liaison between the Bikeway Committee and the Parks and Recreation Board. There was no communication going on, so I started attending the meetings to facilitate that. And since then, there's a member of the board that is also a member of the advisory board. So both the Bikeway Committee, which is a county level organization, and then this organization in discussion here. So there's cross-fertilization automatically now because we have a member that's a member of both organizations. So I have not been attending, but in 2018, I believe it was, there was an attempt to do what's been discussed here. We had one meeting where we met with the Municipal Arts Commission and had a collaborative meeting, discussed about what things we're working on at Arts West, It was a great meeting. We talked about doing it more, and that just never happened somehow. So there was an attempt to do it, and I think it was a good start, but it seems like it would be advisable to pick that up and maybe even have a liaison, like I was talking about, I was trying to do, to increase communication between the Bikeway Committee and the Parks and Recreation Advisory Board, to maybe have some kind of cross-fertilization with liaisons attending both of the Arts and the Recreation Advisory Board meetings to sort of open communication that way as well. So just some suggestions based on what I've seen and what I think was working pretty well.
Thank
Thanks.
you. Additional questions from audience members? If you could follow suit in introducing yourself.
Hi, my name is Beth Braun. I live at 12 Pleasant View Drive, and I'm co-chair of the Athens Municipal Arts Commission. And I have to say that I was somewhat surprised when I saw that this was on the docket for the meeting tonight, because it was the first that I had heard of it. I've been a member of the commission for 11 years. And unfortunately, I have to finally cycle off. But I will say that there's a lot of passion here about the role that the arts play. And certainly the ordinance that the mayor was speaking of, that 0-46-02, that goes back to 2002 when the Arts Commission was created, that is prior to the point at which the Parks and Recreation Advisory Board, it's prior to the point at which the arts were included in that title. And to reiterate what the mayor said, of course, and he said it better than I will, but the purpose of that was to help, because we have Arts West, and it is placed within the Parks and Recreation, and that's a good place for it. So the whole reason, I think, it was a good intention by design to make it Arts, Parks, and Rec. And I think a lot of communities probably aspire to have all of them named together. But I do think that there is a concern about changing the name of the advisory board, since it is an advisory board, just like ours is an advisory board, but yet we are a commission, right? So there's a concern about adding arts to that title. In my perspective, and I do believe that I speak, sorry, I should have said that before, not just for myself, but for the commission, and the other commissioners. So I would say that, yes, there are plenty of opportunities for increased communication, and we welcome that. I think I'm not quite sure why there hasn't been, but I will say that prior to the point at which the name became the Arts, Parks, and Rec Department, it didn't seem like there was necessarily a need for it. So this is kind of maybe a newer need within the last, has it been maybe 4 years, Mr. Mayor? I feel like about that long. Really, I think too that if we put those names together, then we create a bit more confusion. And I do have concerns. While on the one hand, I think it's a great thing that you have arts on your agenda. But if they're regularly appearing on the agenda, then we should be, the chair and myself should be included on those agenda as they are distributed, so that we're able to contribute on behalf of the commission that was, established by this ordinance. So,
thank you.
Thank you. Others from the audience?
Hi, everybody. I'm Chelsea Moorhan, and I live on Watt Street, and I am also representing the Athens Municipal Arts Commission, of which I am the current chair. Like Beth said, we have a lot of concerns regarding the change of the name. Mainly, the Athens Municipal Arts Commission was not told. We were not asked to be involved in the discussion. We believe that if an arts is added to a different advisory board, that we should have been at least communicated to and had a discussion about, because there are different charges and duties within each board. And so making sure that we delineate which ones are doing what, so that there's not a whole lot of it's mine, it's mine, it's mine, but still having those collaborations and those abilities to communicate. So quick thing, so while the Athens Municipal Arts Commission, we make recommendations to the city on public art matters, not just the department. But we've been working with the Arts West and its program specialist since 2005, when AMAC was a partner and founder of Arts West. So most recently, with the help of the new Arts, Parks, and Recreation Director, Catherine Ann Jordan, and the Arts Program Specialist, Emily Beveridge, we have recently started a concert series called Third Thursdays Musical Parks, which I realized this past Thursday that was also the Recreation Advisory Board meeting day. But the first annual event kicked off this past Thursday at the pool parking lot, and it was a testament to the dedication that the new director, as well as the program specialist and AMAC, have to serving their community through the arts. So with that said, the title change could have lasting implications on the Athens Municipal Arts Commission. The Arts Commission is celebrating its 20-year anniversary this year, and our concern is that a newly named Arts, Parks, and Recreation Advisory Board could change the charge of each entity in the process and essentially erase the accomplishments that AMAC has achieved through collaboration with the APR department and the citizens of Athens for 2 decades. We believe that there must be a discussion on why this title change is wanted, and what does that mean for its original charge and duties, and what implications does it have on other entities, including the Arts Commission. I also feel that even on the surface, it seems like it's just a title change. It's just to reflect that it's the current department's name. I feel like there are underlying issues that could result if the title is changed, mainly that this board would be an overseer of the Arts, Parks, and Recreation Department, which it is not, as it is an advisory board that it is mayoral appointed. And then, so throughout these past 9 years, I have actually been involved with AMAC. 3.5 of them has been the program specialist within Arts West, and then 6 years as an AMAC commissioner and now the chair. I know the relationship has not been the best, and I know that we have been trying to work on it. I personally have tried to work on it, but because of the pandemic and other factors, it just hasn't come into fruition. But I am here to say I am open to those communication lines. I love the idea of a quarterly. I wanted to do that. It just didn't happen. So thank you very much.
Thank you. Do we have anyone else from the audience? I think we've had a rich conversation, and I would be remiss if I didn't take the time to thank members of both the advisory board and commission, whose work shouldn't be at all negated through this conversation, which I think is really just meant to clarify and provide opportunity to untie some confusion that has been explored today. So as far as future directions, one question I am left with is the parks part. Seems to be left out of a lot of the conversation where we're talking about arts, we're talking about recreation. So while we see on the agenda Recreation Advisory Board retitled Arts, Parks, and Recreation Advisory Board, I would add a question mark to that as far as what's actually happening. Not to be said that that is what's happening, but as the mayor read, in the responsibilities for AMAC, for the Recreation Advisory Board, we do have parks there, and I'm just wondering, once again to the mayor, like if we do a title change at all, would it make sense to go to Parks and Recreation as having responsibility for those areas, and then keep arts out of that, and then recognizing that there will be potentially occasions when the Parks and Recreation Advisory Board might have an arts topic that they wish to discuss, to do so in more of a collaborative, communicative relationship with AMAC. Mayor, this is your kind of appointed group, so I'm just wondering if you think that makes sense.
It makes perfect sense. You know, again, I'm willing to go through 3 readings, being introduced tonight, to change a title. If it's just a title change, then keep it in alignment with what the mission is for those 2 different organizations. I mean, we're not talking about AMAC here. We're talking about the Rec Advisory Board to include parks. Fine, you know, let's go through
Thank you.
the process to add parks to that.
And to Councilmember Swank, who is a representative on the Recreation Advisory Board, I do think it is important that we move forward with what is established in code as far as responsibilities. That said, it makes sense to me that occasionally arts might enter the conversation, so it seems like it shouldn't be necessarily an expected agenda item at every meeting, but that when we do want to see the Recreation or Parks and Recreation Advisory Board, as it could be named, discuss arts, that we're going to do so with honoring all the suggestions coming, whether it's quarterly meetings or just more collaboration. So I think that's enough discussion for our second agenda item, and I will say that we are done with our committee meeting.
Thank you very much, Councilmember McCary. We'll move on now to Committee of the Whole with one agenda item. This is the last time we'll ask you to move tonight, other than to go home. Yes, okay. We have learned through both former council member Beth Clodfelter, who now represents Senator Sherrod Brown's office, and also through Mayor Patterson, who serves as president of the Mayor's Association, that the Veterans Administration is proposing closing the Chillicothe Veterans Clinic. And that's a clinic that sees approximately 20,000 vets a year and contributes to the Chillicothe's local economy. They employ over 1,400 folks in that community. But I think what's most important is that the service to the veterans and what that might jeopardize by the closing of the facility. I personally, my son is an Army veteran, having served in Iraq and Afghanistan. He lives in Lancaster. He goes to Chillicothe. And to suddenly face going to Dayton would be a stressor. And, you know, there are many who need those services. So I can open it up for any kind of comments. Councilmember Swank first. Yeah.
As I said in a email conversation I had with the mayor Thursday, Friday, not sure which day it was, I had an uncle who was in the first wave of D-Day, Omaha Beach, somehow survived. But when he came back to the United States, obviously long before I was born, as my father tells me, he was very dependent upon services such as the Veterans Administration provides. I'm not even sure if it was called the Veterans Administration back then. But it took many, 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 many years. And finally, he was able to lead a productive life and have 2 children and be a very productive member of society and live to the ripe old age of 90 years old. A lot of our veterans today who don't necessarily fight in combat have lots of issues. I'm wearing a button today that says 22 with a line across it. That represents the number of veterans that commit suicide every day of the year. The thought of making people drive another hour and a half or 2 hours, in many cases not being able to drive an hour and a half or 2 hours to get the services they need is appalling. It's unfathomable. And in the conversation with the mayor I had, I told him that I am very much appreciative of this, and he suggested something, I think he called it a block signature. So rather than just a resolution, and I'm obviously very much in favor of passing this resolution tonight if we could, but I know we can't. Not only passing this resolution, but rather than just having be a resolution of support from city council members, that each and every one of us, if we feel we want to, will sign that in that block and submit it to the appropriate authorities to show our support for this facility that is just so vital to so many people.
Thank you. Any other council members who would like to make a comment? I know the mayor does, but Councilmember Grace?
Just very briefly, I have family members who have worked at the Chillicothe Veterans Center, and I know that it provides a high level of care that is really critical to many vets throughout Southeast Ohio, and transportation is an issue for many in Southeast Ohio, transportation to get to medical services and to increase that barrier I think would be reprehensible, and I'm strongly opposed to the closing and therefore support this. Thank you for bringing it.
Mayor Patterson?
I just want to share with council and kind of put an exclamation mark on the conversation that we're having, and that is that I attended 2 meetings in Chillicothe with Senator Brown, and the most recent one was also with the Secretary of the VA, McDonough, and listening to my, 20 other veterans. I'm a veteran, retired Air National Guardsman, and listening to their stories and the impacts it would have on them. And then myself reflecting and then sharing with Senator Brown and Secretary McDonough, the fact that MPP, Mayor's Partnership for Progress, represents 18 Appalachian counties. That's about 780,000 people. And if you were to apply the percentage of veterans that are in the United States, which is about 7%, that equates to over 54,000 veterans potentially. Here in Southeast Ohio, and all of them, I'm talking from Meigs County to Lawrence County, and everything in between and all over the place, to have to travel, in some cases 3.5 hours to get to a clinic where currently it's taking them 1.5 hours to get there, is, no pun intended, it's a bridge too far for a lot of these veterans. So I appreciate council looking at the resolution that was brought forward by the Mayor's Partnership for Progress and sent on to the appropriate authorities. So I appreciate council taking this up.
Any other? Yes, Councilmember Spielness.
I just have a question. What is the force that is even talking about this? Why on earth is this even a discussion point? Why would they even think of doing this? I'm just shocked that this is even a point of conversation. But don't they get a lot of, anyway, what is the justification supposedly for this kind of move? Do you know?
No, I believe a lot of it is realignment. When they did a lot of the drawdown from military installations, years ago, it was trying to strategically place, which posts, which airfields stay open and which ones are closed down. I think that the VA is exploring the same thing, but again, I would contend the impact that that's going to have on an area of the state that already has our own set of challenges when it comes to us being chronically distressed, and now putting the burden of a further commute. Literally sitting in those meetings with Senator Brown and across from a military member who was fearful of the outcome because of having to go so far. The other thing that was interesting that came out of this meeting is that a lot of these veterans, they feel that going to a place in Southeast Ohio is safe for them, given their conditions that they have, as opposed to having to drive through the big city. There's people outside of veterans that don't like driving to Columbus or Cincinnati or Cleveland or Dayton. And we were hearing that loud and clear during this listening tour that Senator Brown hosted, 2 of them. Given my condition, I do not feel comfortable going into a large city setting to get my treatment. And therefore they won't.
Thank you.
Okay. Well, thank you. Thank you all for your support. Any comments from the audience? If not, we will consider ourselves adjourned at 9:42, and we'll see you next on Monday, June 6th.